SARFAESI and IBC, which is superior? SARFAESI and Insolvency and Bankruptcy Code are two powerful tools in the hands of bankers for recovery of their non-performing assets. SARFAESI was enacted by Parliament in 2002 and IBC came into force from 2016. The objective of SARFAESI is to effect recovery of dues by enforcing securities without the intervention of courts and thereby reduce the delay and other difficulties in realization of non-performing assets. Whereas the objective of IBC is maximization of value of assets, promotion of entrepreneurship, availability of credit and balancing the interests of all the stakeholders. In other words, SARFAESI Act protects financial creditors like banks by allowing them to enforce their security interests without the need for court interference. The IBC, on the other hand, guarantees the interests of all forms of creditors, which are further divided into financial and operational creditors by the court. Both the laws are now extensively and effectively used by bankers for speedy recovery of their stressed assets. Here we are going to see which of the above two acts are more powerful and which has overriding effect over the other one. We will discuss a recent case in which NCLAT, that is National Company Law Appellate Tribunal, has given its decision in a case involving initiation of both SARFAESI and IBC proceedings. This is an interesting case and throws light on the nuances of both legislations as far as bankers are concerned. The case involves Indian Overseas Bank and RCM Infrastructure Limited. The company had availed credit facilities from IOB, which eventually became NPA in the books of the bank. The bank initiated SARFAESI proceedings against the company and took possession of the assets mortgaged to it. The bank also conducted auction of the secured assets. The successful bidder in the auction deposited 25% of the bid amount with the bank and the balance 75% was to be deposited within a period of 2 weeks. In the meantime, the company filed an application under Section 10 of IBC with NCLT Hyderabad and Corporate Insolvency Resolution Process, that is CIRP, was started and also moratorium was imposed as per the provisions of IBC 2016. The bank filed its claim for Rs 79.95 crores due from the company before the resolution professional. Subsequently, the bank received the balance 75% of the bid amount under SARFAESI and filed a revised petition for Rs 46.25 crores after disclosing that they had fully recovered the difference amount through e-auction of the properties. But now the corporate debtor objected to the sale of the assets which they claimed had taken place after the moratorium had been imposed. The NCLT accepted their petition and set aside the sale. In other words, the NCLT set aside the auction and sale of assets conducted by the bank under SARFAESI Act. Against this order of NCLT, the bank approached the NCLAT. This is the background of the case. In this case, the main issues analyzed by National Company Law Appellate Tribunal was: first, whether after imposition of moratorium any transaction done with respect to the assets of the corporate debtor is valid or not. Secondly, whether provisions of IBC prevail over other laws. The bank contended that the auction was conducted and the sale was confirmed much prior to the commencement of CIRP and therefore the sale was absolute. It further submitted that since the sale process commenced prior to CIRP, the moratorium was not applicable to this transaction. It was also contended that the corporate debtor approached the NCLAT without availing the remedy available under SARFAESI Act. It may be recalled that the aggrieved borrower in a SARFAESI action can approach DRT and DRAT under Section 17 of SARFAESI Act. Here, the borrower did not utilize this right but opted to approach NCLT and invoked CIRP. The corporate debtor, that's the company, on the other hand, argued that the sale of the assets had not been completed before the commencement of the CIRP. The bank had conducted auction and the successful bidder had deposited a part of the bid amount only. As per Section 52 of Indian Contract Act 1872, the payment should be made in full, and also a certificate of sale had to be issued for the sale to be complete. Here the balance of 75% of the bid amount was received only after the commencement of the moratorium. Moreover, it was pointed out that on the date of commencement of SARP, the revenue records reflected the name of the company as the owner of the securities. The corporate debtor argued that since the full payment was not received before the commencement of SARP or imposition of the moratorium, the security interest cannot be enforced during moratorium, including pursuing any action under SARFAESI Act. The arguments of both the parties were examined by the Honorable NCLAT, who observed the following. The tribunal noted that the sale was not complete on the date of commencement of SARP, since the total sale price was not paid. Merely receiving 25% of the total sale proceeds prior to the imposition of the moratorium does not signify completion of the sale. The court also pointed out the fact that the bank had claimed the full amount with the RP, that is the resolution professional, initially. It had not taken into account the balance amount receivable from the auction. It proved that the bank had explicitly reaffirmed that the sale had stood unconcluded or it was incomplete. In other words, the appellate tribunal upheld the contention of the corporate debtor, that is the company, that the sale was incomplete when the SARP was commenced. The NCLAT emphasized the importance of moratorium under Section 14 of IBC, which is essential to shelter the interest of the corporate debtor. The moratorium aids in protecting the assets of the corporate debtor, since the primary objective of IBC is maximization of the value of assets. Therefore, upon imposition of a moratorium, no proceedings or auction shall continue or commence against the corporate debtor. Accordingly, receipt of the balance sale consideration of 75% of the bid amount by the bank was illegal. Therefore, the NCLAT gave out its judgment in favor of RCM. It pointed out that as per Section 238 of IBC, provisions of IBC shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. The tribunal also cited its own judgment in an earlier case of Encore Asset Reconstruction Company versus Charu Sandeep Desai, where it had said that Section 238 shall prevail over any provisions of the SARFAESI if there was any inconsistency between IBC and SARFAESI. The NCLAT thus reiterated the overriding effect of IBC over other laws, including the SARFAESI Act, and therefore held that the sale of the assets of the corporate debtor during moratorium is against the spirit of Section 14 of IBC. The important point here is that IBC is not merely a recovery legislation for the creditors, rather it serves as a beneficial legislation to all the stakeholders. This legislation focuses on the revival of the corporate debtor while protecting and balancing the interests of the stakeholders. It is intended to put the debtor back on its feet, not merely to enable recovery of the dues by the creditor. So, IBC is a complete code in itself. Therefore, to sum up, Section 238 of IBC has an overriding effect over all other laws, including SARFAESI Act.